So Congress actually passed something, and on a bipartisan basis, no less. What's the topic? Well, it's about protecting the rights of sexual harassment victims to sue their employer. Let's talk about it in today's video.
My male co-star, who was also one of the show's producers, would frequently refer to me as legs. He would smell me and leeringly look me up and down. Off script, in front of about 100 crew members and cast members, he once said that he would take me to his rape van and use lube and long phallic things on me and take me over his knee and spank me like a little girl. Another time he told me that his sperm were powerful swimmers. These are just a few examples. These were not lines in the script.
Hi, I'm Mike Greiner. I'm a lifelong Democratic activist who's concerned about the direction our country is going. If you share my concerns, maybe you could like this video, subscribe to this channel, maybe even click that little bell that will notify you when I post something new. So you just saw testimony, moving testimony, by actress and producer Eliza Dushku. It appears that she had been recruited to join the show Bull on CBS, a drama featuring lawyers, as it turns out. Well, her co-star and the producer of this show ended up repeatedly and aggressively sexually harassing her. Some of it caught on camera, actually, as she described in the video. And when she went to her supervisors to complain, well, at the network, they were actually supportive of her, saying that she was a great asset to the show and that essentially the producer / co-star should stop harassing her. But what did the show decide to do? Well, they fired her, resulting in CBS having to pay her more than $9 million in compensation for her losses. The reality is, unfortunately, that most women do not have the kind of power that a major entertainment star like Eliza Dushku has. Many of them also do not have employers who are as favorable to their condition as it appears the CBS executives were. Unfortunately, a better example of how sexual harassment survivors are often treated is what happened to Gretchen Carlson from Fox News. Her case, of course, was documented in the movie Bombshell, where it talks about the aggressive sexual harassment she faced from Roger Ailes as an anchor at his network Fox News. Now, you'd think someone in her position would, like Eliza Dushku, have resources at her availability to be able to pursue litigation against her employer. But as it turns out, the contract that she signed with her employer included a provision called an arbitration clause. Now, arbitration clauses are pretty common in most contracts nowadays, actually. Most people don't even realize that they're there, thinking that they're just part of the boilerplate that they don't pay attention to when they sign a contract. The problem is, when you sign a contract that includes such a clause, you are essentially giving up a lot of rights. Pursuant to the Federal Arbitration Act, which dates back to 1926, if you sign a contract with an arbitration clause in it, essentially you no longer have access to the courts to resolve any disputes you have with that employer. Instead, usually, you have to appear before a private party to settle the disputes, often one who's chosen by the employer. A lot of the time, you give up your rights to a jury, and you give up your rights to appeal even. So these arbitration clauses make it much harder to pursue causes of action against an employer. Well, some clever attorneys found a way around this problem, and what it was to essentially gather together sexual harassment cases against a single employer. Because as we know, frequently, when sexual harassment occurs, it's not occurring against just one person. And so what these lawyers are able to do is essentially spread the litigation costs and spread the risk among many people instead of just one person, making it easier for these groups of women, because it's generally speaking women, to be able to pursue these sexual harassment cases. Well, leave it to the Supreme Court to get in the way of that. In 2018, in the case Epic Systems Corp versus Lewis, the Supreme Court ruled that businesses could include in the arbitration clause a provision that makes it that you cannot engage in collective arbitration. Essentially, you can't join your case to other people's to give you essentially strength in numbers as you pursue your litigation against a powerful employer, who already has an advantage given the fact that you're in arbitration in a forum essentially selected and created by and for the benefit of the employer. But then to make matters worse, in 2019, and of course you know which justices were the ones making this decision, it's the 5 conservative ones overruling at the time the 4 more progressive ones, because at the time, Justice Ginsburg was still on the court. And in this case, Lamps Plus versus Varela, the court held that not only can arbitration clauses include a provision that stops the employees from engaging in some type of collective arbitration, but to be able to engage in collective arbitration, The arbitration clause that the employer drafted needs to specifically and explicitly allow individual arbitration. In other words, if the clause is unclear or says nothing, guess what? The employee does not get collective arbitration. These are just two more examples of where this right-wing radical Supreme Court has done everything it can to undermine the right of employees to the benefit of large employers. And not just large employers, but bad actors, for crying out loud. I mean, they're essentially protecting sexual harassers. Well, that was too much for even the MAGA crowd in the U.S. Senate. So on a bipartisan basis, by overwhelming votes in favor of the legislation, both houses of Congress, with the Senate passing it on a voice vote, if you can believe it, passed legislation that has gone to President Biden for his signature to make it that such arbitration clauses no longer can force people with sexual harassment claims into arbitration rather than court. It also makes it that women are pursuing such sexual harassment cases, they're able to do it collectively as a class action rather than be required to pursue it one person at a time through, again, an arbitration forum set up by the employer. This legislation is a huge step forward, both for women's rights and for employees' rights, and it really says something about how out of step the U.S. Supreme Court is with its right-wing majority to the will of the people across the country, that even in this partisan age right now, with the MAGA Republicans in both the House and the Senate spewing Donald Trump's big lie, that they could find common ground to pass legislation essentially to overturn the Supreme Court on this issue. Both Gretchen Carlson and Eliza Dushku, of course, are thrilled that this legislation passed, as are women's advocates and employee rights advocates across the country. I think, frankly, the reason that this passed is because even if the Republicans might consider themselves pro-employer when there are disputes between employees and the employer, protecting employers from sexual harassment cases just goes a little too far. But passing this legislation just shows how Congress is able to overturn bad decisions by the Supreme Court, essentially correcting misinterpretations the Supreme Court has made. They did that on a very significant basis when the Supreme Court was trying to narrow back the applicability of the Americans with Disabilities Act. Congress said, no, we want this to apply broadly, not narrowly the way the Supreme Court is interpreting it. And so Congress passed legislation that made that clear. Similarly, Congress could pass legislation that essentially pushes back against the Supreme Court's assault on the Voting Rights Act. And in fact, there's legislation that has passed the House that would do exactly that. What's more, there are other employee rights that have been essentially cut back by Supreme Court decisions, most notably those involving union rights, where the Supreme Court has a long record of basically doing everything it can to make it difficult for unions to succeed in their efforts to organize employees against employers. Well, again, the House has passed legislation, the PRO Act, that would essentially push back against a lot of these out-of-touch right-wing efforts by the radical Supreme Court majority to limit the rights of unions. This is especially telling at a time where public support for unions is at an all-time high, and just shows once again how the Supreme Court is completely out of touch with the concerns of average Americans across the country. Well, if you like this video, maybe you want to check out another video of mine about the radical right-wing Supreme Court right here. I'll see you then, and in the meantime, let's hope for continued progress. Thank you.